Does the issuer of an annuity in a structured settlement have an obligation to prevent the recipient from selling off his rights to the annuity? To find out, you have to read Cordero versus Transamerica, but it's 44 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of Cordero versus Transamerica. The citation for this case is 39 New York 3rd, 399, published by the New York Court of Appeals on April 25th of 2023. The issue in this case is whether the annuity issuer of a structured settlement has an obligation to prevent the annuity recipient of a structured settlement from giving away or selling his annuity rights. The law you have to understand to appreciate what's going on in this case is first, that there are certain things like toxic torts, for example, lead poisoning, that create a situation where children can get structured settlements, okay? And structured settlements are like annuities that last for many decades, perhaps, and that basically compensates them from their reduced financial abilities in the future. So a child who ingests lead has reduced financial abilities later in life because it results in cognitive impairments or behavioral issues or developmental delays. And this person who has lead poisoning was going to make less money in the course of their life. And so instead of becoming a ward of the state, they can get these structured settlements after litigation that are supposed to provide for them over the course of their life so that they don't become wards of the state. There's an industry called factoring companies. That's the second thing you have to understand. Factoring companies are companies that buy annuity rights, so rights to have money that they will receive over the course of many years in exchange for a lump sum. And there are many famous ones, like there's one called J.G. Wentworth that says, have a structured settlement but need cash now. That's like their tagline. That's a factoring company. A factoring company will take, for example, an annuity that would pay $1 million over a long period of time and instead give you $250,000 now. And so they get the benefit of having this promise of payment for a long period of time, and you get the benefit as the recipient of getting a lump sum right now, even though it's less than you would have gotten. And a lot of these factoring companies will be predatory and prey upon tort victims. As a result, legislatures have passed structured settlement protection acts. These are laws designed to protect victims of toxic torts and prevent them from just giving away or selling off their annuity rights. Because the whole point of that is to protect them, is to ensure that they're not wards of the state, that they don't become homeless and people that can't provide for themselves. So some of these structured settlement protection acts require court involvement when someone's going to sell their annuity rights. And these are in at least 49 states, perhaps all 50 states. I'm not sure about that. And the last thing you have to understand is that there's something called an implied covenant of good faith and fair dealing, which says that the parties to a contract have an obligation to not get in each other's way or prevent or injure each other's obtaining the central promise that's part of the contract. Okay, so what are the facts in this case? The facts are that Cordero was a young child who grew up in an apartment building in Westchester County that had lead in the paint, which apparently is the fact in millions of homes, that there's lead in the paint from before a certain date. And if you ingest that lead, especially young children, they have a high incidence of lead poisoning resulting in intellectual disability. So this child, Cordero, when he was 5 years old, entered into a structured settlement agreement after litigation with his landlord and the insurance company for the building, where he was promised to receive an annuity for 30 years. He would get $3,000 approximately every month for 30 years, for a total of about approximately $1 million, which would help support him in the course of his life because he has reduced ability to earn an income. Now, he then moved to Florida, and in Florida, after he turned 18, 4 years into his 30 years, when he was 22, he decided to start selling off chunks of his annuity. And he sold off 6 times rights to his annuity. And that $1 million of expectation of income over the course of 30 years, he sold for about $268,000. to various different annuity factoring companies. Each time, Florida's SSPA, the Structured Settlement Protection Act, required a hearing be conducted by a judge who would hear whether it was in the best interests, whether the transfer contravenes the law, whether it's in the best interest of the recipient, and whether the amount paid is fair, just, and reasonable. And the reason why you have to have these SSPAs and the ability to sell your annuity is, what if the person is going to become homeless? What if the person needs the money for a medical procedure? There are emergencies that pop up that the person may need a lump sum now instead of $3,000 per month. So each time Cordero had these hearings, he didn't show up, the factoring company showed up, and the judge never knew, apparently the judge allegedly never knew at any of these hearings that Cordero had lead poisoning, and approved, rubber stamped essentially, perhaps, each of these transfers, resulting in Cordero having $268,000, but then nothing going forward. He then sued. The litigation is he sued. He didn't sue the factoring companies who took his money. He sued the annuity issuer, Transamerica, who issued the annuity, for failing to object, for failing to stop Cordero from selling away his annuity rights. That's this case. So the holding from the New York Court of Appeals is that, yes, the contract required that the annuity be made to Cordero, and that, yes, it said you can't sell or assign your rights, but there's not but what you're alleging, Cordero, is that the Transamerica violated not the contract, but an implied covenant of good faith and fair dealing in the contract, that the Transamerica failed to object to Cordero doing something that would hurt himself. And here, there's no such duty. Here, the Court of Appeals says there's no duty on Transamerica's part that they have to protect Cordero from himself. That would make Transamerica a fiduciary, and they're not a fiduciary. Contracting parties are not generally fiduciaries of each other. They have to protect each other. That's not the annuity issuer's job. That's the judge's job in the Florida SSPA court, the Structured Settlement Protection Act hearing court. There is a dissent here by Judge Rivera, and she agrees with the majority that Transamerica doesn't have a duty to object, but she says they breached their implied duty by failing to advise the court at those hearings that Cordero had lead poisoning, that he was mentally impaired or developmentally disabled. She spends dozens of pages, or a dozen pages at least, talking about how terrible lead poisoning is and how the real objective of the contract is that Cordero receive a stable and secure future. And here, Transamerica breached that by failing to at least let the court know at the structured settlement hearings that Cordero had lead poisoning. So she dissents and would reverse based upon a breach of implied duty to let the court know what Cordero's situation was. But the majority decision here is that Transamerica, as a contracting annuity issuer, does not have an obligation to object or interfere with Cordero selling his annuity rights. And that's the case of Cordero versus Transamerica. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.